Thank you for joining us today for an update on topics and issues we're seeing in this current real estate market. I'm Laura Prouse with Crest Insurance Services. Today, we welcome attorney Mark Carlson from the Carlson Law Group. Mark has been defending real estate professionals since 1993 and has worked with Crest for over 20 years as a founding member of our legal panel. Along with Mark, we have Dave Miller, Regional Vice President of Fidelity National Home Warranty. Dave manages the Crest Advantage Home Warranty Plan, which ties into Crest's E&O insurance. We have a lot to cover and a lot of updates to do today, so I'll go ahead and hand it off to both of you.
Thanks, Laura, for the introduction and for being with us today. Mark, thank you for being with us today. You know, it's been a few months since we've talked about some of the major issues in the California real estate market, and I kind of feel like since those few months have passed, it's kind of been like the Wild West. You know, the inventory has been extremely low. There are 10 to 15 offers on every property. And contingencies seem to me to be a thing of the past. And luckily, I think over the last 3 or 4 weeks, things have started to normalize, which is probably good for everybody. So I wanted to get back with you and just take, get some updates from you on a few different topics. Mark, how are you doing today?
I'm doing fine, thank you.
Good, good.
Let's talk back doing this again.
Yes, yeah, and I know the members of Crest and all the real estate professionals in California appreciate these very much. So we're happy to continue to do them. Let's talk about property management for a moment. An eviction moratorium, I believe, was extended till September. What update do you have for the real estate professionals, and do you see any other extensions coming? And if so, what are we going to continue to see?
Well, when the moratoriums will ultimately lift, of course, is unknowable. It is a highly politicized issue, and I'm sure landlords who are out there that aren't getting paid rent and who were unable to get the advantages of some of these relief programs administered by the state, from the federal monies, they just want to get back to normal, and so, but it's all these issues have just made it so complicated that whether you're a property manager or whether you're a listing agent looking to sell a property that's tenant occupied, you still, like we mentioned in the last seminar on this, you got to have your owner, whether it's in a lease situation or whether it's on a sale situation where you're trying to list a property for sale, have the owner go get legal advice, go to talk to their attorneys, find out exactly what's going on with this particular property. In the city and the county that it's in, because there are a lot of overlaying restrictions as to moratoriums. The statewide moratorium that we've talked about is, just one of things that could potentially impact an owner's ability to evict a tenant.
That's crazy. So if these continue to extend, do you see those maybe happening into next year?
Well, so I think in the last go around, the extension to September also contained a clause that said local ordinances can't extend beyond that. So the question really becomes what's going to happen with the state. But then you see, again, it's such a highly politicized issue. You see the Supreme Court statement that the federal eviction moratorium couldn't or was only allowed to extend, or I'm sorry, was only allowed to go through when it expired. And then there was a statement that if it were to extend beyond there, it couldn't be done by the president, it would have to be done by Congress. But then you see members of Congress that are saying, well, you should just do it anyway. And so, you never know what a local municipality is going to do in the face of state law. So it really is hard to know. You just need to have. This is one area where agents, whether they be property managers or listing agents, just need to punt and have their clients go talk to an attorney and get advice from them, because it's just too complicated for an agent to navigate.
Right. In your opinion, is this whole eviction moratorium, is it directly tied into COVID? Like, if the cases are getting better across the U.S., is this going to possibly go away? Because it seems like now the cases are getting worse, and now, on the street, we're hearing that it could go a lot longer because of that. Is it directly tied into COVID in cases?
I don't think anybody knows that, because these moratoriums just come out of the blue. right? It's all of the California ones have all been extended within a day or within 24 or 48 hours of when his predecessor was going to expire. And so they just come out. There's just no way of knowing.
That's crazy. Well, let's talk about non-contingent offers. I mentioned there was a Wild West period where there were, so that buyer's offer was hopefully more acceptable and accepted. There were no contingencies. And of course, you've mentioned to us in the past the dangers of not having, home inspections and, maybe pest control or home warranty and stuff like that on there. What update do you have on maybe the pitfalls of just, I guess, more from the buyer's side for non-contingent offers?
Well, we're seeing, as we run the CREST risk management line, and then we have another risk management program that we handle calls for. And we're starting to see just recently houses being on the market a little bit longer, offers not being, or offers containing contingencies not being non-contingent, which I think is good because it's dangerous, as I previously mentioned. So hopefully the market and I know that it's probably like putting fingernails down a chalkboard to say, hopefully the market's cooling off, because, the industry professionals always love a hot market because everybody makes more money.
Right.
But I think the market being as hot as it was and pressuring agents to recommend or go along with non-contingent offers was really just an unnecessary risk. So, and from that respect, I'm glad that it seems to be cooling off, but who knows? Maybe it goes back to where it was. I'm just saying or telling you what I've been seeing lately through our risk management programs.
Right. And I think you mentioned to us a couple of weeks ago, you're seeing an uptick in contingencies for sellers, and that there's a form, the seller's purchase of replacement property form, the SPRP. What exactly does this form do, and how does it help the sellers?
Well, so when a seller in a tight market like this wants to sell their property, obviously they want to have a property to move to, unless they're just cashing out of the market, which some sellers are doing. But the seller purchase of replacement property form was revised in 2017, really to make it more user friendly for real estate professionals. The prior version of the form did not clearly state when the inspection periods and when contingency periods on the well, I guess what they call the down leg transaction would occur. Is it upon acceptance of the buyer's offer, or is it upon removal of the seller's contingency, once they find replacement property? So the form is a little bit more user friendly, but it really should be filled out carefully because you don't want to have a circumstance where the seller can't find a property because the market's so tight, or gets beat out on a number of offers that they try to make, but then is locked in to sell their property, because that's when they nearly 100% of the time sue their listing agent saying, "What'd you get me into?" Right.
Let's move over to wire fraud. I mean, I was just watching the news this morning, and a company was taken for $610 million. This is just not going away. And of course, it's heavy in real estate too. But what continual issues do you see with wire fraud? And honestly, what can real estate professionals and buyers and sellers do to protect themselves?
Yeah, they're getting more sophisticated all the time. And just when people figure out solutions to stop it from happening, the bad guys come up with new methods in which to dupe people out of giving or sending money to false bank account addresses. And so really it just is diligence. It is calling before and after you send a wire so that the people know it's coming. And then calling to confirm that it got there. Not if you have a telephone call from somebody, and this just happened about 4 months ago to a client or on a case that I was involved with, where somebody had called and said, "Yeah, I'm so-and-so from ABC Escrow. I need you to send, I need to have you fill out this information so that we can, adjust, the wire." And so people are now impersonating the professionals that are involved in the transaction. And it isn't just a matter of emails like it was before. And so you have to be really diligent, double check whenever it comes to a wire. You have to, again, a call before and a call after, because if if you send a wire and then you call who you think you're supposed to be calling, and they don't know anything about it, then you've got 24 hours in which to stop the wire. But if you don't do that, then after that 24-hour period passes, it's nearly impossible to get that money back.
Oh, and the one you told us about, I think it was $100,000 or something like that. It's
Yeah, well, it can be seller's proceeds, it can be buyer's deposit, it can be refund of buyer's deposit if there's a canceled transaction. I mean, any time that there potentially could be a wire of size, that's where the bad guys are trying to pounce on.
right. And of course, we always see at the bottom of every escrow officer's email, under their email template, a disclosure about wire fraud. And there's, we will never ask you for X, Y, and Z and stuff like that. So are those helping, I would imagine?
Well, who knows? I mean, everything together is helpful, but it's when you look carefully at emails that start the wire fraud process, there's always something in there that identifies, or that would allow you to identify it as a fraudulent email. It could be Mike Jones, and there's two I's in Mike versus one, and that's how the bad guys do it. They create fake URLs, and then they make subtle changes to the address. Mike L. Jones, whereas before it was just Mike Jones. And then, but the research shows that people spend something like less than 1/10 of a second looking at the line. So you're just sort of looking at the ray line just until your mind processes, okay, I know who that is, and then you go on to something else. People don't normally read the address lines critically.
Right. Let's move over to a subject that I think, and we've talked about this before, I think many are overthinking this, and it's the HHDA, the home hardening. I think the bill was passed in January, AB 38, which was the home hardening bill. And then in July, we had a recent update with defensible space. What's your take on this bill and specifically the form, the HHDA, and what can parties do from a risk management standpoint to be in compliance?
Well, so it is an effort, of course, by the state to try to get people to create defensible spaces around their property, and knowing what that defensible space means is important. So let's start with that, and then we'll roll into what the form requires. So defensible space, it's in Public Resource Code 4291, and there it's defined as sort of two zones. The first within 30 feet of the house, and then secondly within 100 feet of the house. And the idea is just to properly maintain vegetation so as not to allow extra fuel or unnecessary fuel to crowd around a house that could exacerbate or make that house more vulnerable to fire. So there isn't a black and white standard. It just is a maintenance program or effort in order to minimize the risk. And in fact, within the Public Resource Code 4291, it specifically says that single specimen trees or other vegetation that are well pruned or maintained are exempt from the requirements. So now you're hearing people like, well, I might have to, if I don't properly figure out whether my house is in a high fire zone, and then the buyer might be left with having to, spend thousands of dollars in weed abatement, or cutting, big trees down. Well, that probably is not going to be the case. I've been litigating cases on behalf of brokers since 93, basically. I've had exactly 0 cases where there was a circumstance where a fire marshal came by and ordered a bunch of things to be done with the property after close of escrow, and the buyer was upset that they had to comply. There aren't in most jurisdictions. Now there could be some, so you have to be careful. I'm not saying this is a blanket rule, but in most circumstances, you get a weed abatement note, and the fire department just sort of comes by and makes sure. And if you don't, they pester you again. It typically is not, a circumstance where the fire department or local fire marshal are requiring you to re-landscape your property to be in compliance. So But with that said, the form is now required. Well, the form is created by CAR in order to contain the disclosures and warnings mandated within the statute. And so if a property is built before 2010 and is in a high or very high fire zone, then the disclosures need to be given to the buyer. It also is only required when there's a transfer disclosure statement that's required. So if you have a house that's being sold in the administration of a trust, or if it's an REO property, or the other sort of not often seen exceptions to when a TDS is required, then you don't have to provide the home hardening form either. And so then the question that we're getting from everybody is, well, how do I know if it's in a high or very high fire zone? Then it also applies outside of those zones if you live in an area where you abut up against sort of rolling hills and vegetation. So if you're lucky and you get that nice view of your house on a development and you're at the very end and you overlook a great big canyon, whether you're in a high or very high fire zone, you're going to have to make the disclosures, assuming it's built after or before 2010 in that circumstance as well. And so the question about, well, where do I find it? Well, take a look at the NHD report, right? That's where it's typically listed there. Although that's unfortunately not, a one-stop shop, because sometimes it'll be missed in the first, the hot sheet, or they call it. I'm not the one-page summary that's at the front of reports. Sometimes it isn't there, but it's buried, back within the body of the report. So it's important to look through the entirety of the NHD report to see whether or not it's in a high or very high fire zone. It can also be too that a property is not listed in a high or very high fire zone, but it's in a wildfire overlay kind of zone that then the statute doesn't apply to that. Okay, what if I'm in a fire zone, but it's worded something differently than high or very high? So the statute allows a seller to make the required disclosures, even if it's voluntary. So maybe I don't know, and I'm having a tough time figuring out, or the report I got back is confusing. Well, there's nothing wrong with the seller making the disclosures in any event. And all the disclosures are there certain characteristics of the house that are listed on the form that make the house more vulnerable to fires. So, you could have a seller could take the approach, I don't know one way or the other, but I'm going to fill it out anyway. So then I know I'm covered irrespective.
Right. Did I hear you mention that this bill doesn't apply to houses built before 2010?
No, it applies to houses built before 2010. So if it's built after 2010, it doesn't apply.
Gotcha. Okay, perfect. And of course, I'm a little bit biased, but Fidelity National Home Warranty has Disclosure Source, NHD, and we're all over this. And our reports obviously have the home hardening in there and the disclosures about the fire zone, not only on the summary sheets in the beginning, but through the report extensively. So real estate professionals can check that out. Mark, anything else on home hardening that you want to add?
Yeah, so there's another part to it that is, I think, causing a lot of people consternation also, because it talks about written proof that the property is in compliance with defensible space. And so there's no strict requirements, and most fire jurisdictions don't have a procedure to do an inspection for whether property is in compliance with defensible space. But assuming for whatever reason that the seller within the 6-month period prior to the offer had a report or a note from a government agency saying that it was in compliance, then the seller has to give the buyer a copy of that report. If there's a local ordinance that requires documentation of compliance, and there are some, I've heard just on an industry meeting earlier this week that Marin County and there was another county up in Northern California, sort of in the northern Sierra Nevada area, have compliance ordinances. And so if there is a local requirement, then the buyer must agree that within a year, they'll obtain the written documentation that they're in compliance. If the seller has one, then the seller has to give that, or if the ordinance requires that the seller obtain the written compliance or documentation of compliance, then the seller has to provide that 5 days prior to close of escrow. Again, so those are ones where it's hard to give a standard rule, because it depends on what the local ordinance is, and that could change as things go forward. We're just at the very beginning of this, so you could have local governmental entities creating ordinances that don't exist now.
So we have a new bill, we have a new disclosure, and we have a new CAR form. I mean, we've had hundreds of those over the period of years, but why is everybody overthinking this one? Is it because it's just something new?
Well, I think because it's a mandatory form, and we haven't had a mandatory form, I think, since the transfer disclosure state, either lead-based paint or I'm testing my own memory on history here, but we haven't had a mandatory form in an awful long time. So that gets everybody, up in arms. And then it's okay. Well, if it's mandatory, then I must obviously pay close attention. Otherwise, I'm going to be liable. But, really, again, I think that the risk of, or the exposure, if this is done improperly, is fairly remote. It's meant really just to educate people to look at their house and see if there's ways that they can prune and maintain the vegetation in such a way to make it less vulnerable to fire. But really, for there to be a claim arising out of this form, you would have to have a fire after close of escrow, and then somebody is able to show that, but for the mistakes on the form, that fire, or that the house wouldn't have been damaged in the manner that it was in that fire. So you can see it's kind of a remote, circumstance. And then the other potential risk is, if a buyer buys a property and then in order to obtain written documentation of compliance, that they have to spend a lot of money in order to do that, which again, it's hard to know because there aren't very many local ordinances currently.
Right. If the NHD report fails and the disclosure fails, who's ultimately responsible? Is it the sellers or the NHD report, the NHD company?
Well, that's a good question. You're talking about a statute that's not even a year old yet. But if a seller could say, you know what, I'm going to voluntarily make the disclosures anyway. I don't care what they could say. I have an NHD report here that says that I'm not in a high fire zone. But you know what? I would like for my buyer to preserve this home because it's been in my family for generations. And so I'm going to make the disclosures anyway. That's perfectly fine under the statute.
Good. Excellent. Well, we have we've talked about many different topics today, and kind of going back on ones that we've talked about in the past. And Mark, we always appreciate your time and giving us an update on these, because there's something new every month. So we look forward to the next time that we get to meet with you. And again, we thank you so much for your time. Laura, back to you.
Great information as always. Like you said, there's always something new coming in on the market. So it's great that we're able to give this information out. Mark, Dave, thank you so much. Really appreciate your time, and I'm sure we'll be meeting again soon. And for those of you who are watching, a copy of this webinar is available on the Crest Insurance homepage if you look under the Claim Prevent blog.